Hello, my name is Kathleen Flynn from the law offices of Kathleen and Flynn in Decatur, Georgia, just outside of Atlanta. We help people obtain Social Security disability benefits from the Social Security Administration, as well as veterans obtain veteran service-connected benefits from the Veterans Administration. Today I'll be focusing on how to prepare for a Social Security disability hearing. Typically, a Social Security disability hearing will last anywhere from 45 minutes to an hour. I've noticed in recent years that some of the newer judges want the hearings to last no more than 45 minutes. In some cases, my associate or I have had to ask for supplemental hearings because a judge may spend most of the 45 minutes asking a claimant about his or her past relevant work, that's any work performed in the last 15 years or some other questions about conditions and symptoms. And this leaves us, as the attorney questioning our client, little time to develop the case. So we have to ask for a supplemental hearing provided the client consents. So what will you be asked at your Social Security disability hearing? It depends on who starts the questioning. Some judges like to take charge of the hearing and ask the questions initially. Other judges allow the attorney to start the questioning. Typically you're asked identification information, your last grade attended school, your date of birth, when you last worked, why the job ended, then your prior work activity covering 15 years may be discussed and why you can't perform that work today. If you can perform any of your jobs in the last 15 years, you will be denied. You may next be asked about all your mental and physical conditions and the symptoms arising from those conditions, in addition to the limitations that those conditions cause. For example, if you're diagnosed with panic attacks, you might be asked what symptoms you have from panic attacks, such as shortness of breath and sweating. And then you might be asked what limitations you have from the panic attacks. Can't leave the house, can't handle stress. There are a whole series of questions that can be asked about symptoms and limitations related to each condition. You will be asked what you do on a typical day. A lot of judges like to ask if you can drive, can you do the laundry, can you grocery shop, do you do any house cleaning, do you take care of children? And a lot of these questions are asked at the lower level, the initial or the reconsideration level, in a daily living questionnaire. And the judge might reference back to what you wrote in the questionnaire to see if you said one thing in the questionnaire and now are saying another. Some of the big limitations that we focus on for physical and mental conditions are difficulty concentrating, difficulty interacting with supervisors, difficulty handling work stress. You may be asked how long you can sit, stand, walk, lift, carry, whether you have limitations in bending and stooping, whether you have to elevate your legs due to swelling or pain, and how high you have to elevate. You may be asked whether you have difficulty using your hands to grasp objects or to finger in order to button, for example. Whether you have difficulty reaching out in front or overhead or to the sides. This is just a broad overview of the type of limitations you may be asked about. Now, this is a good opportunity for your attorney who's read the file thoroughly to bring out anything in the file that needs to be addressed. For example, I had a client with substance abuse in her file, and the file noted that she went to bars and played pool. So we had to address that, and fortunately we did because it was brought up in the hearing. Or I had another client, and this happens unfortunately when clients can't afford to get to the doctor or fill their medication, who may have gaps in treatment or not have medication. The Social Security Administration considers good cause reasons for not pursuing treatment or medication, and one is inability to afford it. Some other questions that might be asked are, what medications are you taking and what side effects do you have? I've never won a case based on side effects of medication. However, it is something that has to be considered in a decision, and if it isn't, it's appealable error. You may be asked about your treating doctors or psychiatrists and whether or not they were willing to fill out paperwork for your disability hearing. You may want to present a witness, and some judges routinely will decline the request and ask, will the witness provide cumulative information or corroborative information? And in that case, they'll say that the claimant, him or herself, testified to the same information that the witness may provide. I try to stand firm on asking for a witness, particularly if a client requests it. If the judge doesn't want to take the time for witness, the judge may ask for a statement after the hearing, which obviously isn't as helpful as an in-person account of the claimant's symptoms and limitations and difficulties performing activities of daily living. I hope you found this overview of what to expect in the hearing helpful, and stay tuned for future videos. If you need help with an SSI, SSDI case for an adult or child, or help with a service-connected veterans case, please call us at the law offices of Kathleen and Flynn, LLC at 404-479-4431.